Hello, mate. I've not seen you for, well, not since yesterday when we were at a council meeting, but on the podcast, I've not seen you since we were in a pub a few weeks back doing our last podcast.
I've completely forgotten what we do and how we do it.
And that one was a little bit different, wasn't it? Because we were doing that in real life with a real audience and guests sat in front of us and not on Zoom and things like that. How's your life been recently? You've been quite busy, haven't you, I think?
Yeah, I've been zipping around quite a lot. I'm more tired than usual, but very enjoying it. Actually, it's good to be back, Lee. It's good to be back doing this. Apparently, I'm not allowed to talk about the wallpaper that's behind your head. Is this correct?
Well, no one can see it, so there's no point, is there? Unless I take a little photograph of it and we add it to the socials for the podcast.
Well, it's like a nuclear war in a broccoli factory, is how I describe it.
my wife would be telling you it's William Morris or something like that, but I don't know. I just hang the stuff. I get told what to do, and I just hang the stuff. Yeah, I'm just back from holiday. I took the time out to have a little break.
So I hear that you bought a joke.
I bought a joke. Yeah, I was on holiday in St Ives, and we went out on a little kind of like drive aroundy thing, and ended up finding ourselves in Penzance, just stopping for guacamole. We were looking for the evening's fajita meal. And we were walking down Penzance High Street, whatever it might be called, and there was a homeless guy sat outside one of the shops there. And as we walked by, he said something. I didn't quite catch what he said, and he shouted it a little bit louder. And it was like, "Do you want to buy a joke, mate?" And I thought, I've never ever had anyone on the street trying to kind of cadge money off me say anything like that. So I turned around and I bought a joke off him.
Go on.
Are you ready for it? So
I'm ready.
So he only wanted £1 for this, but it was so good. I gave him a fiver.
Okay, well, we can value the joke at the end.
So, and he put an accent on, and it was what's a parrot's favourite letter?
I don't know, Lee. What's a parrot's favourite letter?
Well, I of course said to him, "That's not a good joke, mate, because it's R."
Yeah.
And he went, "Oh no, it be C." And I thought that was so funny. Well, parrots go to sea with pirates, yeah.
Oh,
and I'm imagining he's developed this joke, so it doesn't matter what you answer. He can flip it. So if I said, it be C, he would have gone,
Okay,
yeah.
I see how, no. It's the multi-purpose use that maybe gets the extra £4. I see it now.
Yeah. Should we get a guest on?
That's good.
Lee Davis and Gwilym Roberts are the two IPs in a pod, and you are listening to a podcast on intellectual property, brought to you by the Chartered Institute of Patent Attorneys.
Hey Tim, welcome to the podcast, sir.
Well, thanks for having me. It's first time I've been on one of your podcasts, so for a quick introduction, I'm Tim Sampson, I'm a barrister at Lamb Chambers. I specialise in intellectual property and construction law. Bit of a strange combination, but I've been doing that for the last 25 years now, so it's I'm unlikely to change. Obviously, we're here today because of a Supreme Court case that I was involved in, led by Peter Knox, and we got judgment 2 months ago now, but my involvement goes back more than 5 years on this case.
Wow. When
the Ahmeds staggered into chambers with a dozen boxes of papers and a panicked look on their face saying, "Tim, we don't know what to do."
So Gwilym was explaining to you before we started the podcast proper that we have quite a mix of an audience. We obviously have CEPA's members, IP professionals who, whilst they wouldn't be over the detail of this, they're going to understand it from a legal context. But we also get inventors and students and all sorts of others listening. So do you want to kind of ground us in this from basic first principles so we understand the case and where it originates?
Right. Well, this case, many moons ago now, 2017 in fact, started off as a bun fight between Lifestyle Equities, who are brand owners. So essentially they have a stable of trademarks which they license on to other people. My clients, the Ahmeds, and the companies that they were running at the time were alleged to have carried out acts of basic trademark infringement, 10.2, 10.3, and passing off to the common law rights provisions. They were found, or the companies were found to infringe the trademarks. There was an order for an account of profits to be taken, so the standard remedy at the end of that trial. But Lifestyle weren't happy to just go against the company. They wanted to wrap the AMIDs, the directors of the companies, into the case and pursue them for an account as well. So the company side of it was all dealt with post-trial, monies were paid over, the companies were wound up, all gone. Second trial happens just against the directors, which is where I get involved. And the point Lifestyle were making is that not only did they want to come after the directors for the salaries that they'd earned whilst the infringing activities were taking place, had gone on, so 6 years worth of salary, or a proportion of that salary, they also wanted to say that company loans made to Kashif Ali, were also recoverable as a profit. And then the big one, the fact that there was monies to be had out of the companies in the account that hadn't been recovered. And Lifestyle said, well, actually, that's fine. We'll have that money out of the AMIDs as well as part of the account, which meant they were liable for enormous, potentially enormous sums of money, millions of pounds. And the crucial point being, most of that money had never been in their hands.
So in your experience, is it unusual for litigation to proceed like this? Is it unusual to go after directors that haven't achieved a settlement at kind of company level?
No, it has become more and more common to try and wrap directors into IP proceedings, because you can imagine the problem. You've got a big claimant company, small defendant company with a couple of directors. If the directors are named personally in the proceedings, they're going to sit there and think, if we lose this case, not only is the company going to go down, I'm going to personally lose everything. So it puts a huge amount of pressure on directors. And the crucial thing that before this decision of the Supreme Court was that the liability as joint tortfeasors, which is what is alleged against these directors, was strict. So if trademark infringement was proved or patent infringement was proved against the company, there was no defense for the directors to say, we didn't know we were infringing anyone's rights, we didn't act with any improper motive, we were just running the company and we made a mistake. And the court would go, well, that's lovely, but unfortunately, you're still liable. So there was no escape for the directors.
Gwilym, your witness.
Thank you very much. That's interesting. So people were going for the directors more for tactical reasons to kind of maybe pressurize a settlement, or was it because they actually wanted to go for the liability recovery?
Well, it could be for a number of reasons. I mean, I've dealt with cases like this where the director, and it was a single director, set up the company, and it was quite obvious the sole purpose was to trade in infringing goods and pocket the money. The company itself had no assets, all the money had disappeared into the pocket of the director. And in those circumstances, a claim against the director was entirely appropriate. But there are many cases where it seems to be extremely difficult to justify why the directors have been brought in unless it is to pressurise the new settlement. And the difficulty there is you've got directors going, my duty under the Companies Act is to protect the interests of the company. If I go all out to protect the company, I throw myself under a bus. So I'm going to throw the company under the bus first. And that can't be a satisfactory outcome.
In some ways, it seems odd that in 2024, this comes to a head. Why has it taken so long for this to get settled when you put it like that?
Well, I think it's a combination of more and more of these claims are being brought. And it took somebody, in this case, the AMIDs, with the preparedness to actually say, no, this is wrong and we're going to fight it out. And there has been a view in the courts, certainly the High Court and Court of Appeal, that the question of the liability or the standard of liability for directors, joint tortfeasors, has been dealt with, and that's it. It's strict liability, just as it is for the tort itself, the trademark infringement or patent infringement. And this is really the first time the Supreme Court has sat down and go, no, let's look at this from first principles. What is it that makes someone an accessory to the tort? And if you look at the law, the way it's developed, and Lord David goes through this in quite some detail, it was never the case that the fact that the tort, trademark infringement, whatever, was a strict liability meant that the accessory liability of the directors was also strict. It had become accepted without anyone really thinking why.
Which I guess can happen, and it's good that it's been tested. So is the kind of outcome, in more plain words, that if you have a situation where a director has been siphoning money using the company as a front, so going for the company doesn't get you the fair redress, it addresses that activity would still be effectively caught. But if you've got somebody who's just basically being a director and didn't realise the implications of what they were doing, then they wouldn't get caught. So it's kind of bringing some fairness to the situation.
Yes, and of course you've got to remember that the company will always remain liable because it's strict liability on the company. So it's not as if you escape scot-free and the poor claimant is left with no one to go after. But you've got a situation where what the court has said is that if you knew of the essential features of the tort, or you deliberately turned a blind eye to what you were doing, you're going to be caught as the director. But what you're not going to have is situations where directors who behaved honestly and completely within a sort of frame of directorial probity, but just got it wrong on the law, are not now going to face personal ruin off the back of it. And this has been the situation for many, many years in Canada. And one of the cases that was considered by the Supreme Court was a case called Mentmore. And there, the directors the company was found liable for patent infringement, but the directors were not, because the court said it took the court 4 days to work out whether there was patent infringement. How could lay directors possibly understand what they were doing was infringement? Otherwise, you've got to say that even if there's the slightest chance of infringement, you can't do what you want to do, which is a very stifling way to run business. So you have to have that fair balance.
Yeah.
So if you take the example, the Amex case is a good example. When they started using the trademarks, there was no question in anyone's mind they were infringing. They weren't even aware of the claimant's marks to start with. They'd also got advice, or the companies have got advice from reputable trademark agents saying, no problem here. Your only slight issue might be you're using polo players and a polo sounding brand. And of course, we all know that the granddaddy of those brands is Ralph Lauren.
Yes.
But, there we go. That's the market you're in. It goes to the European Trademark Office. And there's a challenge when they're registering some of these marks. All the issues that eventually came up in the 2017 trial were ventilated, and the Trademark Office said, no, not a problem. You can register those marks. There's no confusion in Lifestyles marks. So they behaved in a completely appropriate and honest way. Why would you think, having been told by your professional advisors and then advised the same thing effectively by the European Trademark Office, oh yeah, you can do all of this, and you go, you know what, we better stop because we might be infringing someone's rights. So that is where the Amex were. But then they get caught several years later for trademark infringement. And they're then on the hook personally for the account of profits, supposedly, certainly according to Lifestyle. So where we are now is a situation where an honest director who goes off and gets advice and acts on that advice can say, well, look, I did not know what I was going to do would be infringement. And it's even and equally important that directors that choose not to take advice or don't consider the possibility, i.e. they've turned a blind eye, they can get caught as well. So the answer is to find out what it is you're doing and get advice if necessary, and then you're protected. Whereas prior to this judgment, you could be in a situation where you got advice, you've done everything right, or apparently everything right, and you're still liable. So the guilty party, the person that deliberately set out to infringe, and the innocent party who didn't want to infringe, are equally held liable. There's no distinction between the good and the bad. And that really brings the law into disrepute.
No, it makes a lot of sense, but and also it kind of mitigates aggressive litigation tactics the other way as well, which is let's go for the directors because that's going to put them in conflict with their own duties and et cetera, et cetera. So it does sound like a good balance. And as you say, that due diligence point, that businesses take risks, but when they take considered risks, that's what business is. So you have to do that. I think if you personally were additionally liable, then it would change your own risk profile. The business would do their thing. Oh well. It is interesting. I was going to ask, actually, if I may, getting things to the Supreme Court isn't trivial. So this was considered to be in the public interest, presumably. How does one get that far?
There's the public interest element, and also the court will say, is this the right time to consider this issue? And obviously, the court thought it was the right time to consider it. And there are more and more of these cases, coming before the High Court. So it was a situation where you wanted to know, is the right test being applied? And the answer was no, it wasn't. And that then feeds into the remedies and how things like accounts of profit actually work. And the confusion that's arisen with what so-called innocent infringers being caught with accounts of profit and whether that's right or wrong. And that's dealt with later in the judgment.
So I think I was interested, what's the commentary been like from kind of external observers? Has the consensus been this was a loophole that needed tidying up, or people said it's all gone horribly wrong, or where are people sitting on it?
A mixed bag. I think there's been a certain degree of difficulty for the legal profession, certainly barristers, because you've got cases before the courts and you're now being told actually your pleadings will have to be amended to deal with making proper allegations of guilty knowledge or deliberate turning of a blind eye. But that will all pass a few months, 6 months, a year from now. Everyone will know what the right way to go about it is. But there has been some commentary saying this is an infringer's charter and it will let the guilty off the hook. Well, I think that's just not right. Firstly, it's not changed the liability for the companies. So the party that is actually carrying out the illicit trade, the infringement of the patent, the infringement of the general, is still caught. And they're still on the hook for damages or on account of profit, just as they always were. And only directors that did not have the knowledge, the essential features of the tort, or turn a blind eye, will get off. And you could say, well, let's look at a jurisdiction where this has been in place. So go back to Canada, Mentmore, late 70s. They bring in it's not quite the same test, although Lord Leggett said he had a great deal of sympathy with what the Canadian courts were trying to achieve. And in many ways, it is essentially the same outcome achieved with a slightly different wording. And then you look over the next 40 years of Canadian cases, has it let infringers off the hook? And there's case after case in the federal courts in Canada where Mentmore has been applied and directors have been held liable. But in circumstances where you can see the directors were clearly guilty. And it makes it much easier then for infringement proceedings to be brought against guilty parties, because you can say, look, you knew what you were doing was an infringement and you carried on and did it anyway. So you're bound to rights, to use the vernacular phrase. So it's certainly not, places like Canada, caused a problem of going after directors who've chosen to behave badly. So it's not an infringer's charter.
Can I ask what might be a daft question? But I'm allowed to ask the daft questions, Tim, because
Right.
I'm not a proper IP professional like Gwilym. So I'm just an enthusiastic amateur, having learned this over the last 13 years. So lot of talk at the moment at CIPA Council and around our committees about the UK IPO's intention to consult more widely on designs, and particularly unregistered designs. There will be within that at some point the discussion about further criminal sanctions for unregistered designs. So is there a read across? I understand that the case that we're talking about here is the liability and the infringement is clear, trademark. How does that read across to the world of designs and maybe particularly unregistered designs?
Well, the issue is always going to be for the accessory liability, did the party have the requisite knowledge of the essential features of the tort? So we're just thinking about director's liability here. But if you go, obviously you're about unregistered design, but if I can just reverse back into copyright, for example.
Okay, yeah.
The same act. Now, the Copyright Act has already dealt with this issue because under section 16, it says that if you authorise the acts of infringement, you are guilty of the acts of infringement. So there are statutory provisions that already deal with this situation. I can't remember off the top of my head whether there's an authorisation provision. I don't think there is. But that's where we're at. So if you're in a situation where it's copyright infringement, you're not going to be in this. The directors can't say, well, all I did was authorise it because you're already caught by the statute. This case won't help you because you're already caught. This is a common law remedy where there is no statutory provision. But you've got to look at it across the whole gamut of IP rights.
It is interesting when what I describe as the risk profile shifts, because a topic that came up in the meeting Lee and I were at yesterday is criminal sanctions for certain areas of IP infringement and kind of, the sharp end of design law and things. And again, it makes it quite difficult to run a business if you get that profile wrong. If the sanction is too harsh or unfair, then you make the bad decisions, I suppose.
Well, yes, we mustn't confuse what the Supreme Court were looking at in lifestyle with any criminal provisions.
Oh, of course.
Criminal mens rea will have to be there. And that's not touched on in this judgment, and it obviously wouldn't be because it is purely a civil matter. But with criminal matters, it is too tricky. Just going off on a tangent, I've dealt with counterfeiting cases where you have the client going, look, okay, I accept the goods are counterfeit, but I sourced them from what I thought was a completely legitimate source. And now I'm being told I'm criminally liable for having sold them on. So yes, you could see that it's difficult. Now, whether or not that story I was being told by my client was a shaggy dog story, it's difficult to persuade the court to believe actually you could get trapped by other people's dishonesty.
Yes.
Look, you had a shop load of counterfeit vodka. Do you want to explain what you were doing with it?
It does sound like you've had quite an interesting, varied litigation career. And you mentioned at the beginning that you do IP and construction law. They are both about property. For me, that's the nexus. But how those two unlikely sounding bedfellows in your kind of portfolio?
Well, I originally spent a year before my pupillage working in a very small solicitors firm attached to a very big QS management firm dealing with construction sites. So
Nice.
I was off onto construction sites, writing reports about contracts, doing extension of time claims, that sort of thing. And having done it for a year, I rather enjoyed it. So even though I did a pupillage in intellectual property set, I never quite weaned myself off construction law.
And in terms of the level of amazing cases that you get involved in, which brings up the more entertaining angle, the IP side or the construction side?
The most challenging are the IP because they tend to be the more difficult cases in terms of the law. Whereas the construction cases, there can be complexities, but there are factual complexities. And often, or more often than not in the last few years, it has been because someone can't pour concrete properly. Another expert report dealing with concrete, I think I will go mad.
We've just done a podcast about self-healing concrete, haven't we, Gwilym?
Oh, yes, we have. Yes, you're quite right.
The stuff the Romans produced, or some modern variant of it.
Yeah, no,
Ooh,
this
that-
one can you remember how it works? There's some kind of internal vein structure, wasn't there, where it mends itself through
Yeah, it leaked out healant. I
yeah.
think it was something like that. Yeah. But no, and so in terms of I know that litigation always brings out the exciting moments and the characters and everything. Where do you find the big characters coming out? Is it more on the construction side or the IP side?
It can be any of it. Any case that fights to trial will usually somewhere along the line involve big characters. So in this case, it was Kashif Ahmed who was driving it, and he had the guts to say, "No, we are not going to go down on this. We are right. This is wrong. It's got to be challenged," and somehow managed to talk Peter Knox, Casey into leading it, and me into doing it for 5 years on a no-win, no-fee, and persuade RFB to act as solicitors for it. I may have told RFB that there was nothing much to be done and it was more a post-box position. I'm not sure they've quite forgiven me for that. So, yeah, litigation tends to, if it's going to settle, because people are nervous about litigation, that's what happens. If you've got people who've got the guts to fight it out, they tend to be big characters.
Yeah, and I mean, one thing I don't know, Lee, we've had too many barristers we've had quite a few judges on the podcast. I'm not sure we've had that many barristers. And it's such an interesting world to be in. And in particular, the up on your feet aspect. So I guess that the variety of characters you deal with, you're still doing the same job on the day, I suppose, which is interesting. One final question from me, actually, just in terms of background. So what got you moving towards the bar in the first place? How did you come down this route?
Well, when I was finishing up my PhD in Cambridge, I decided that I had sort of fallen out of love with biochemistry at that point. And I thought, well, what else can I do? I'm getting a bit long in the tooth to start all over again. And then I thought, well, actually, the bar sounds quite fun. I didn't know that much about it.
Mm-hmm.
That sounds quite an interesting job. So that's really what got me into it. And then you get on the treadmill of doing the conversion course and the bar finals. And then 25 years later, you find yourself still doing it. And your first, I think my first case was in Ashford County Court in front of some bored deputy district judge. And then, you end up in the Supreme Court many moons later.
Love it.
I was in the Supreme Court on this one for 2 days, on Monday and Tuesday. On the Thursday, I was back in Romford County Court doing some absolutely minor building case. So the bar can also bring you back down to
It's good to have the balance. Do you ever use your biochemistry, or is that something that's now just tucked away?
No, I do. From time to time, I do advisory work on patents that can require quite a detailed knowledge of biochemistry, molecular biology. You can't really do the work unless you've got that basic understanding of scientific terminology. Otherwise, it would just mean nothing to you.
So Tim, at the outset of this, we characterised our audience as being wide ranging. But let me give you two different constituents in our audience. There will be some people listening to this, perhaps running small businesses, who may find themselves either being infringed or infringing at some point in the future. What would their takeout be from this? First part of the question. So how would you summarise it for them? Second part of the question, of course, we've got SEPA members listening to this, either running individual or small practices, or some of the biggest practices in the UK. What should the IP professional take out from this?
Well, the IP professional, or anyone involved with IP, should, I think, be relieved about this, because it will mean litigation focuses on the parties that have really committed the acts of infringement. Honest directors doing their best are not going to be found liable. And in some ways, that makes everyone's position much clearer. If you're not thinking am I going to be sued? Or should I be suing Mr. or Miss X because they're running that company and I think they're infringing my rights? It brings the litigation into focus. And for certainly the smaller practitioners, we've got IPEX, Intellectual Property Enterprise Court, which provides a very good venue for not no cost, but nicely capped costs.
Yeah.
So you can see that if you don't start wrapping directors in, that framework for a more restricted cost framework for litigation works better. If you suddenly start having the company and directors involved, it becomes more complicated. Costs go up proportionately. Not focusing on anything useful, just really going to bite someone for the sake of it. So I think this will have the judgment should have a salutary effect on the way litigation is being run. And in many ways, that's good for everyone, because the aim of people exploiting IP and creating IP is not to get involved in instructing people like me to go off and have a fight on their behalf or defend them. Ultimately, we are parasitic on the intellectual creations of others. And yes, there will always be bad people out there that need to be brought to book. But that's not what we're talking about. They'll still be brought to book. It's not a question of letting the bad go. It's just making sure the good don't get pursued.
Thank you for that. Thank you so much for taking time out of your busy schedule to come on the podcast and explain the case for the listeners. I'm sure it will be well received. Gwilym, I have a little question for you at the end, if that's okay.
Of course.
So, if people have listened to this podcast and found it interesting, what should they do?
I could do this one. They should write a review, Lee. A good review. Importantly, don't bother writing bad reviews. We've got plenty of those.
We have to.
We have our fine. Yeah. No. Yeah, they should write a review, Lee. It's very important, and that's how podcasts grow and thrive. And they will write a good review because it's a great podcast.
Yeah. It's so lovely to see that you're learning and you're becoming quite the podcast host.
One day.
Yeah, I did see, because Kilburn and Strode are always very good at promoting the podcast on LinkedIn. And I did see that you were described as star podcast host Gwilym Roberts and his co-host Lee Davis. So thank you so much for that.
I told to call it a sidekick. How irritating. There we go.
Tim, thank you so much for coming on. It's been a pleasure.
Not a pleasure as well. So thank you very much for having me.
Thank you.